patent family member in Saudi Arabia? Do I expand it to the Gulf states? Do I expand it to other countries in the world? And knowing how much is right for your particular company is an important thing to understand. At the yellow level you see there in the center, it's could I be more competitive by licensing out to other people? Should I? Shouldn't I? And then at the green level, it's how can I bring the technology in? And do I understand how I can get the technology in from the universities and in from other companies so that I can generate more wealth for my own company in its service to society? So here are some very specific questions that relate to those overall intellectual property roles that we have. I put this slide up because some companies have gone even further, and what they've done is they've started to build dashboards so that the answer to that question is either yes or no, or as you see here, a diagram like a speedometer. We're very weak. No, we're going very fast and we're very good at it. And so companies have been thinking about, well, how do I answer those questions in a way that helps a management team understand, is it competent in its management of intellectual property, or is it an area that they still need to focus on and build? Again, this is one example. It's one way to look at it, but the key thing is that they have a way to now start looking at measuring specifically the answers to the questions. And this comes back to a comment that I made earlier. Several hundred years ago, people did not have access to data and information to know how things were going. And that's different today. We can gather information in a way that can make a display like this possible. And because it's possible, we can now do a much better job of managing our companies and our intellectual property than ever before. Specifically, for just one of those little indicators, in this case, should I be out-licensing my technology or not, there's on the order of 30, 40 indicators that most people that are working in this area feel that for some industries indicate whether or not they should be or are they in a position to out-license. Around the position that you see in red in your upper left, all those little indicators, and what you see is that red line with the dots is the specific company's performance, and you'll see some that it's all the way out at the horizon, which means, boy, it's really good, and then you'll see some that there's nothing there. They haven't a competency in that area. So if you look at the ones in the upper left, what you'll see is there's one or two that they've done well on, the rest they're weak. And those have to do, how do they work with the patent office? Are they working well? Are they not doing a particularly good job, and later on they're going to have a problem with their patent? And in this case, this particular company's kind of so-so. In the ones in the lower left there, it has to do, well, what do you think the strength and the utility of the patent is? Is it going to be something that's really useful to the world? Is it something that the world is reaching for and looking for? Or is it something that's maybe unique but commercially not interesting? And here again, you see this particular company has a few measures that say, boy, it might have something that's really unique and useful, but in other areas, not so much. And the last area that you see on the right-hand side has to do with the geographic reach. And in this case, the company's doing very well. It's doing very well in the sense that it's filing a lot in Asia. It's protecting itself in China, Japan, India, Australia, Taiwan. It's doing a so-so job in the U.S., and in other areas, it's absent. For instance, in France, in a particular area, in Europe. So, looking at these measures, you get a sense for: will it be valid and enforceable? Is it going to be strong or weak from a technical and commercial standpoint? And is it going to be protected? Will we get a sustained advantage around the world or not? And all of those measures summed together give you a sense for, is licensing this technology going to be something that's going to be a good or a difficult thing to do. I put this up not because of the specific metrics, but to show you, to illustrate you that the statement I made that intellectual property management, it was an art, it's converting into a science. And I think that's very important for you as the audience to realize, because the world is just learning how to do this. It's something that anybody in the world could choose to do with their time and energy, is to also participate in the learning of how intellectual property moves from an art to a science. It's an area of opportunity for everybody. I'm going to close by putting up this quote. It's a gentleman whose name you might remember. I'm not putting it up for that reason, but to point to you that this particular quote was in 2004. What I don't have available, because I can't find it, I heard Bill say it, but I never saw it documented in writing anywhere. But in 1990, he said, basically, Google's comment that I gave to you on the first page. And that was, I don't need any intellectual property. I don't know what it's good for. I really don't think I need to worry about it. Here it is, 14 years later. Oh, gee, I have a business problem. It's something I should have paid attention to a long time ago. It's now my responsibility as a leader to lead my company, to understand. I have to understand it as Bill Gates, the chairman. I expect everybody in my organization to do so as well. So it's with this transformation that I think I'd like to close by saying that I hope I've shown you some examples of how intellectual property has made a difference to corporations and how you can manage the complexity that it's now converting from an art to a science, that it's important for leaders in a company to care about it. And in making the point then that intellectual property strategy is absolutely key to success in the knowledge economy. I showed you the underlying technology, political, and information systems that make that statement true, that it's the intellectual property that's protecting the investments that people are making, and that lastly, it's something that's achievable. You can do it, and it really does make a difference in revenues and profits. Thank you so much for your time and attention.
شكرا دكتور باول. ننتقل إلى الموضوع الثالث في هذه الجلسة، فهم إطار العمل الدولي لبناء استراتيجيات ملكية فكرية، مع السيدة سارة هولدر مدير شركة راوس لمنطقة الشرق الأوسط شمال أفريقيا.
Thank you very much for the kind invitation to come and address you today. I'm also going to address you in English. I have much less of an excuse than Paul, because I actually live in the UAE and have done for 6 years, so I do apologise that I can't speak Arabic. Today I'm going to talk about the International Intellectual Property Framework and how this can help drive decisions about intellectual property strategy. The two speakers before me have covered some of what I was going to say today, so I hope this is not too repetitive. I will try not to make it repetitive, but maybe also I have a slightly different perspective on things based on my experiences, particularly in working in developing intellectual property jurisdictions. So first, I'm just going to have a simple look at some of the framework of intellectual property law, the sources of law, intellectual property law, that we can all rely on, and the advantages of the international framework. And then I'm going to look at some of the intellectual property strategy building blocks, specifically where there is creation, protection, and exploitation of intellectual property. Firstly, sources of international intellectual property law. Well, the first port of call is international treaties. These provide the framework of all intellectual property law across the world. We can think of them like the skeleton. These treaties allow us to talk a similar language across borders, an increasingly borderless world where businesses operate. And that's important because intellectual property rights, for the large part, remain territorial, so you must go and seek protection in each country that you need protection in. But businesses are not operating in with these territorial restrictions often. So having sitting sometimes above or sometimes alongside local legislation will be regional groupings. The most obvious one that we've heard about today would be the GCC patent law. But there are many, many examples of where countries have got together, they have common interests in the protection of intellectual property. So some other examples would be the European patent, the community trademark in Europe, ARIPO and OAPI, which are two African organisations which allow you to apply for patents and trademarks on a regional basis. Okay, international treaties can be broadly divided into treaties that set out minimum standards for protection. Examples of these that provide guidance would be the Paris Convention, the Berne Convention, which deals with copyright, and the TRIPS Agreement. There's also treaties that deal with global protection systems, so the Madrid Treaty and the Madrid Protocol in relation to trademarks, and the Patent Cooperation Treaty, which, as you all know, provides a conduit for filing an international patent application. I would say probably the biggest misconception I face in my practice is people coming in and saying, I want to apply for one of those international patents, and the faces fall when you tell them there's no such thing as an international patent, only an international patent application. The next category of international treaties is the classification treaties. So these help us divide up how we assign protection of trademarks, of designs, of patents, and these treaties, or some of these treaties are listed there. So the Nice Agreement, Strasbourg, Locarno. And I've just put up a website link there that gives you a very comprehensive list of all the treaties that are administered by the World Intellectual Property Organization. It's a very, very handy website to go and look at if you want to know which countries are members of which treaties or when they acceded to which treaties, or need to look at the text of any treaty. I would just point out here that the one major intellectual property treaty that is not administered by WIPO is, of course, the TRIPS Agreement, which is administered by the WTO instead. Okay, moving on to the muscle on our skeleton, the local legislation. We have country or sometimes regional legislation, which may consist of intellectual property laws and regulations, so specific patent laws, a specific copyright law, a specific trademark law. But often we find sources of intellectual property protection in non-specific laws, and it's particularly common in developing intellectual property jurisdictions to find issues like confidentiality or trade secrets protection that you have to fight for the source of protection. We have to go to general laws, often the general commercial laws, to find the relevant protections. Unfair competition is another intellectual property area where we often have to go to these general laws, and there are often no specific laws. Very, very important in the local framework as well is how the courts are interpreting intellectual property. I've mentioned that the international framework is very much allows us all to speak a common language, but local courts will always interpret that language, and what gives users of intellectual property systems confidence is if they are aware how a specific concept will be interpreted in a specific jurisdiction. So judges, not to put any pressure on one of my colleagues who's going to speak after me, have a very, very important role to play in issuing clear, well-reasoned decisions that give confidence to the business community that intellectual property will not only be respected, but allow them to understand how that country sees intellectual property and how that they should therefore incorporate that into their strategy for protection and exploitation of their intellectual property in that territory. Okay, just to as an example, I just thought I'd look at patents quickly. So the big three international treaties governing patents would be Paris Convention, which looks at such concepts as the first filing concept, which establishes your priority date. One of the very notable non-members of the Paris Convention is Kuwait for this region. I don't know if they have any plans to join, but that is one of the exceptions in this region. The TRIPS agreement expands on the Paris Convention, and we start to really get some detail around issues such as compulsory licensing, emergency use of patents, and issues like that, which are increasingly important in our world, and particularly in the debate around pharmaceuticals. And then the Paris Convention, which now has 146 member countries and allows this international filing conduit. Saudi Arabia has joined the PCT but has yet to implement it, and I believe that the GCC Patent Office may be considering joining. Okay, so the advantages of the international framework, as I've mentioned, ease access to intellectual property protection. Now, some people might say that this is a way of developed countries dictating to less developed countries in terms of being able to protect their own businesses and allowing their own businesses to exploit intellectual property in developing markets. And probably nowhere is this debate more ferocious than surrounding the issue of proprietary pharmaceuticals and the issue of generics. Regardless of whichever side you are on in that debate, and I won't open the floor to debate because we may be here all afternoon, there is a very, very strong correlation between strong and robust intellectual property systems and economic development in countries. Intellectual property is generally considered to be a good thing, and that international framework allows us all to access that good idea in a very similar, unified way. The international framework also unifies important concepts and procedures, but as we've already heard today, there are some exceptions, such as countries may decide what they exclude from patentability, or countries may decide whether they apply the principle of exhaustion of intellectual property rights. So it all sounds great in theory, but you still need to understand local practice and legislation, even though we have this overarching international framework, because local practice and legislation can often be non-compliant with the international treaties. As I've mentioned, there are certain permissible exceptions, so you need to know in any particular country that you are executing an intellectual property strategy, you will need to understand which exceptions have been put into local law in that country. And therefore, we need to take all of this into account when devising intellectual property strategies. I'll just move past that because we've done that. So some basic elements of intellectual property strategy. This is the way I simplify it. I think Paul has given us also a very good viewpoint on this. Creation of intellectual property is, in my view, the first step, and then looking at how to protect that. And then once you have something protected, how do you exploit that? So in the creation field, we have obviously, probably the one that people think of most is employees. Your employees are generating intellectual property every single day that they come to work. They may or may not know that, but they probably are. And that is generating, if you can identify and capture that, then you will be able to exploit that. I would say probably one of the other really big things that I see in my practice in the UAE is a lack of understanding from employers how they take ownership of intellectual property created by their employees. You may also be licensing in technology or licensing out technology. You may be working with contractors who are creating intellectual property for you, and you need to understand that that has been created so you can take ownership of it. You may be involved in joint development agreements with academic institutions or with other businesses in your specific area of industry who've all got a common goal in developing a new area of technology. Your creation of intellectual property may be driven, well, should always be driven by your business and what your business drivers are, and also what your competitors are doing. Not suggesting you should engage in industrial espionage, but there's a lot of information in our current world with media that you can find out about your competitors and what they're doing. Then we need to look at protection. So you need to assess the intellectual property that's been created within your business and then start to make some decisions about that. How should you use the international framework I've just been talking about to decide whether you're going to file for patents? Are you going to file for patents in the 146 member states of the PCT? Very, very few companies would do that or even have the means to do that. So you need to be starting to think about how you can delay decision making or which countries it's important to get fast patents granted in, and using your knowledge of the systems, both the international framework and your experiences of working in specific territories to help you make those decisions. You need to be communicating within your business about this decision-making process, and equally also making sure that no one is communicating with the outside world until you have decided whether you're going to pursue patent protection. And of course, once again, all of this needs to be done in alignment with the overall business strategies. And then moving on to the last section, which is IP exploitation. You should, again, business strategy has to lie alongside your intellectual property strategy. Your intellectual property should give you a commercial advantage. If it doesn't, then you should be questioning why you're bothering protecting it. Does this give you an advantage over your competitors? Are your competitors interested in what you're doing? A lot of this is important. These are important questions to ask around strategy, because if competitors are interested, then you may want to try and expand your area of protection to keep them from getting close to your area of technology. And very important, and one that I also see a lot of businesses in the Gulf possibly not undertaking often enough, is reviews of their intellectual property. Are they deploying the intellectual property that they have? If they are not, are they looking for commercial opportunities to license out that technology or to sell that technology, to divest themselves of it for some kind of financial gain? Or are they just simply paying annuity fees for no reason, and should they just allow a patent to lapse? So I sum up sort of some key intellectual property strategy requirements as requiring robust internal procedures and training. It's critical to identify IP creation within business early or within academic institutions early to avoid disclosures that may then impact how you may protect this intellectual property. And again, as I said, I think managing your employees and your contractors and your contracts that you enter into is absolutely critical. And I see that as something that many businesses don't actively do, and this is where a lot of problems arise when they suddenly realise they have a valuable piece of intellectual property and may have lost the ability to exploit that. You also need to have a good knowledge of the protection systems. For example, when might you want to use the Patent Convention, PCT, versus the Paris